Well, I am not standing chairman, but I will convene this meeting. Let's continue with the markup copy. Now we are on paper 2021/13 to 14 bracket 01, page 1. You all have the marked up copy? Yes. Let me refer to page 1. Accrued benefits. There is an amendment. This is to clarify. Investments of the contributions, but taking into account any losses in respect of the investments and any amount paid in respect of the scheme member. This is a technical amendment to bring the definition of accrued benefits more in line with reality. And we have added an additional definition. It is constituent fund, which wasn't there before. It refers to, in relation to a registered scheme, means the fund that constitutes the scheme or a fund that forms part of the scheme. Let's continue. We now jump to page 5. It's also a technical amendment. When it comes to permitted period, the definition has been expounded. It means for a relevant employee who is not a casual employee, 60 days, or for a casual employee, 10 days. Because sometimes when we calculate permitted period, say for example, the time to make contribution payment, and when it falls on a public holiday, or Saturday or Sunday, we would like to just clarify. Any questions? Well, when it comes to 60 days, do you take into account working days, public holidays, or? Because what if it's at the end of the 60th day and there is a typhoon? Can you explain the two together? The part at the bottom as well. Perhaps I will supplement. If you refer to page 5, bracket 13 and 14, it is to clarify if the last day specified in subsection 14, and if it is a Saturday, public holiday, or a gale warning day, or black rainstorm warning day, the end of the permitted period still expires at the end of the 60th day or 10 days for a casual employee. So it will not be extended even if it is a stay specified. So whether it is a rainy day, one that is hit by typhoon, it will still expire. So it's very rigid. Is that right? Do you understand? Any questions? No? Please continue. Let's now move on to page 8. Oh, what about page 6? Section 10, subsection 2, page 6? Yes. It's in relation to the maximum income level. When it comes to notification, it has to be done in accordance with section 7A. That is, an employee who receives the notice under subsection 1 must give effect to the election by making deductions and making contributions in respect of the employee in accordance with section 7A. That is, if the income is more than the maximum level of relevant income, then a contribution has to be made. But there is no change in policy. So it's just an improvement in the text. Page 7. And this is important. This is in relation to the accrued benefits. Currently, you can only make a lump sum withdrawal. And in the arrow on page 7, you see that you can do it by installments now. Under 2A, there is a consequential amendment by adding by installments. If there are no questions, next page. No, sorry, no, at the end, there is a square. The scheme member's terminal illness. This is also an important amendment. One more reason is added. If the scheme member is terminally ill and there is a certificate from a doctor saying that the member has only about 12 months or less left, then he can withdraw the accrued benefits.
If there are no questions, we can go on to page 8. That triangular one, a mark is a more important amendment. I'd like to clarify what is meant by a scheme member who has permanently ceased employment. We say here that a scheme member has permanently ceased employment or self-employment if he has ceased all employment or has ceased all self-employment with no intention of becoming employed or self-employed again, respectively. Well, I'm not as quick as you are. Can we go back to page 7? 15, section 15, there is the deletion. 3B, deletion of incapacity. The scheme member's total incapacity. No, there is really no amendment. We have changed the punctuation mark only. We have replaced it with a semicolon and add a conjunction. I don't know whether a question I once raised has been answered or not. A person is terminally ill and has less than a year to live, and yet he's really unconscious. So how can he draw his accrued benefits? Then under the mental health ordinance, he can apply to the court for the appointment of a committee of estate to deal with his estate. His committee of estate. Oh, okay.
No.
Any other question? Ms. Sit Ho? My question is on page 8. That triangle. Can I go to that? Sure. So I'd like to know whether Mr. Sin Chung Kai is done. Oh, Mr. Sin Chung Kai, are you done with your question on page 7? Okay. Then we can we move on to page 8? Should you first explain the amendment to us? I already did. Now it's Ms. Ho's turn to ask question. I'd like to know whether this concept is found in other parts of the ordinance. Because you talk about cessation of employment or self-employment. Yes, there can be objective evidence. But although he has no intention now, he may have the intention to be employed again tomorrow. I'd like to know whether there's been any precedent. A person had no intention to become employed or self-employed, but then a few months down the road, he had to work again because of financial needs. Now, this is quite a common issue. I have encountered it at the MPFA, but you can't be too strict. You have to consider each case on its own merits. So, DS, can you tell us how do you deal with such cases? No, this is actually about early retirement. A person can apply to withdraw his accrued benefits on the basis of early retirement. Well, at a certain moment, he may want to retire, but sometime afterwards, for whatever reasons, he wants to be employed again, that is allowed. Currently, he has to make a declaration a statutory declaration, and the wording is very rigid. It appears that a person cannot join the workforce again after he has declared to retire early. But if there are changes to his financial situation, he can join the workforce again. I'd like to know whether this concept of no intention is found in the principal ordinance. DS, can you explain to us whether you have this concept of no intention in other parts of the ordinance? What DFJ colleague can help? If it is about being employed or self-employed again, well, this concept of no intention is something new to this bill, and therefore in the principal ordinance you cannot find this phrase no intention. Well, I wonder whether the fact that the person has no intention at that point is really legally binding. So can you give us a copy of the statutory declaration so that we know how it was done in the past and how this can be done after the bill is enacted, and then I can follow up at the next meeting. We do have this document. We can give you a copy of the existing document and the amended version to you later. Yes, thank you. Because I really wonder how you can prove in law a person has no intention, and what if he changes his view in the future or his intention in the future. Since this is the first time you introduced the concept of no intention, we have to consider this more carefully. Now, if you tell us that in 2002, when the bill was enacted, when the ordinance was enacted, there was already this concept, it's fine. But if it is new to the bill, I really want to discuss further. All right, we'll provide the documents to you later. Any further questions? No, then page 9. Page 9. DS, please go on. The triangle on page 9 is all the way to page 11. This is a rather important amendment of the bill. If I may ask members to go to page 11 direct. Subsection 6. 21A, BA and 21BB. Now, if a trustee would like to add new funds, the authority has to be satisfied that it is in the interest of scheme members. Otherwise, the authority has the statutory authority or power to reject such funds. So I'd like to draw members' attention to this point. And we discussed last time whether there should be guidelines for the authority to consider. And we said last time that the authority would issue the relevant guidelines. DS, our legal advisor has a question. Thank you. The administration has already taken us to page 11. I think this is a textual drafting issue in 8B of the Chinese version. Now, if the authority rejects an application for approval or cancellation, it must include in the notice a statement setting out the reasons for the rejection.
Now,
usually the Chinese rendition for the word include should be 包括 instead of 加入 to add. can you tell us what's the difference between 包括, which is include, and 加入, which is add? Legal advisor, can you tell us what's the difference between the two Chinese terms legally? Now, to include, that is to 加入. 加入 should be to add. Something is really not there and you add, and the Chinese term should be 加入. Include or 包括 means something should contain this. In Cap 485, there are different places, including 20, capital A, capital B, and 34A, and 34B, and 21, and 11, where a statement is mentioned and reasons to be included. I think for the sake of consistency, we should have the same Chinese rendition for this word include. Either we use 包括, which is closer to the meaning of include, or 加入, which means to add. Then can we ask the administration to respond? Do you have a question? My question is for our legal advisor. I want to seek the legal advice of the council first. Which one would you prefer? Which Chinese rendition would you prefer, legal advisor? We have to put the word into the context, and let's see syntactically which one is more desirable. Well, the question is, there are other provisions with the word include, and members may want to be consistent and use the same Chinese rendition for the word include. I think before we decide, we should listen to the administration's explanation first. DFJ? Perhaps the DFJ would agree to this amendment. DFJ? We have the view that the meaning of the Chinese word here is just the same as the English word. And why have we gone for the Chinese word, Chinese term 加入, which means add? We believe it would express the meaning better. So we have chosen to use the word 加入, which means adds, to improve the text. All right, do we agree? And if you would like to comment on this, can you raise your hands, please? This is rather technical in nature. I think our legal advisor will discuss with the DFJ after the meeting. We can't arbitrate because it's really a legal issue, so it should be settled between the lawyers. DS? Now, if members agree that a new fund can only be added, if it is in the interest of scheme members, then we can go to page 12. Okay, page 12, no change to the English text. Because the term is mandatory Provident Fund Authority. However, in Chinese, the term authority is rendered into a 監督, more like a supervisor or watchdog. I would like to change it to 管理局. All right. Page 13. The authority may not disclose information of scheme members. However, there are some conditions under which the authority may disclose such information. Now, we say here that when information may be disclosed for seeking advice from or giving advice by counsel of solicitor or other professional advisor acting or proposing to act in a professional capacity in connection with the matter arising under this ordinance.
And under the square, you will find that there are some circumstances the MPFA may disclose information of scheme members to some regulators and government departments. We have taken reference from other regulating provisions in the financial services sector. We would like to specify the government departments and regulators to which information can be disclosed by the MPFA. You'll find a list of the bodies. I won't read out their names. You see that they are regulators or financial services and the Inland Revenue Department, Ms. Sit-ho. In relation to the deleted bracket D, under subsection 1 of 42, now there is a list of 1 to 15. Some of them are newly added. Say, for example, Secretary for Justice, the SFC, the Privacy Commissioner for Personal Data, the Ombudsman, the Registrar of Companies, the Financial Reporting Council. In the original version, it was quite general. It's just said that it's necessary to enable the exercise or performance of a function imposed or conferred by law. Now you have made a list. So is it, well, what if in the future you have missed somebody and you'll find yourself restricted to this list? Please refer to D15. That is, a person authorized by a person or body specified in subparagraph 1, 2, 3, 4, 5, 6, or 7. The FS, in exercising his power, may make appointments to require the MPFA to disclose information to a specified person. So under 15th is somebody that the, say for example, the FS or the S4J specified. Well, what about the views of the sector? Our concern is that if it's a set list, then you are putting yourself in a straitjacket. And on the other hand, there may be too much power conferred. Legal advisor. Ms. Ho, you may refer to Section 42D, the original version. It has actually listed out the different bodies. For me, the amendment, apart from the additions, say for example the S4J, the Privacy Commissioner for Personal Data, it's actually similar to the old version. If someone else is to be added, then it's down to the administration to decide whether it will be by way of subsidiary legislation or a blue bill to add someone. Well, I was only referring to page 12. Actually, in page 13, you will find that there are some circumstances. Say, for example, it's to help the Director for Inland Revenue to exercise its power. On page 13, you will find in the triangle that the authority will have to satisfy that it is in the interest of the scheme member concerned, it is in the public interest, and it enables the performance of function imposed or conferred by law. So what if it's the director, but the commissioner for labor? If the commissioner would like to get some information, then he will have to get an authorization from certain officials. Is that right? Under D, if it's someone that is not named, then the MPFA cannot make a direct disclosure. Save and except in D15 that the official, say for example the FS, specified a body by giving authorization for the MPFA to give information. However, in this circumstance, page 13 will have to be satisfied as well. What has there been in the case that where the Commissioner for Labor wanted to get some information and the Commissioner succeeded? I'll refer to the MPFA.
There's been requests from the Commissioner for Labor, as an example. I think the objective here was merely just to, because this was being amended, to align this with what is in other pieces of legislation. But we certainly take the point there's a balance here between being able to be flexible and not having too broad a power. So I think we've taken this to what's in other pieces of legislation. You may be right. There may be practical examples where someone does want something and they're not in the list. That is problematic. But if there was a broader test, it becomes problematic because this information is very sensitive.
Just now, the DS in answer to 1 capital AC on the previous on page 13, well, actually he has more or less answered my question. Perhaps maybe we can supplement information as to whether there has been actual cases when it comes to, say, the Commissioner for Labor getting information or asking for information. Mr. Sin Chung Kai. Originally, the provision is not as wide. Now it seems to be a bit too wide. Well, I made a juxtaposition and I find that the Director for Inland Revenue was not there. Sorry, actually, is there. Who has been added? Who has been taken away? We have added Secretary for Justice, Privacy Commissioner for Personal Data, the Ombudsman, the Registrar of Companies, and under 15, a person authorized by a person or body specified in subparagraph 1, 2, 3, 4, 5, 6, or 7. Perhaps let me repeat. Newly added, as for J, Privacy Commissioner, Ombudsman, Registrar of Companies, and Roman 15, person authorized by a person specified in 1, 2, 3, 4, 5, 6, or 7. What do you think the main purpose for giving information to the Privacy Commissioner and the Registrar of Companies? Well, that will be in relation to the investigation of privacy protection for law enforcement. We have taken reference from some ordinances. Information may be disclosed to these officials. Say, for example, under the SFCO, the Securities and Futures Commission Ordinance. What do you mean? Well, we have taken reference from some new provisions in legislations that information can be disclosed to the Privacy Commissioner. Any more questions from Mr. Sin? On the left. It is the authority reasonably believes, and I see that it is changed. that the authority may disclose information if it is satisfied that you change it because you think it needs to be changed. But what is the difference? That is, the authority may only disclose information if it is satisfied that. Well, now under D on the left-hand side, you'll find that requirement. Please refer to page 12 on the left-hand side at the end. Is in the interest of scheme members, public interest necessary to enable exercise of a function. I understand that, but what about the line above that? Only if the authority reasonably believes that the disclosure. Well, that is the draft style. Perhaps I'll defer to the DOJ. Please refer to section 42. Under 1D, only if the authority reasonably believes. In English is the authority reasonably believes. So the legislative effect has not been changed. It's just that the location has been changed to bracket 1A. Please continue. We take the chance to change the Chinese rendition so that it will be closer to the meaning in the English version, but the requirement is exactly the same. Any other questions? Please continue. DS. Let's move on to page 16 of the Chinese version. That is page 15 in the English version. The triangle on the right-hand side, that is, if information is disclosed by the MPFA to a recipient, the recipient shall not disclose the information to another person unless consent is obtained from the authority to the disclosure, or the information can be obtained in the public domain, or the purpose of the disclosure is to seek advice from a counsel, solicitor, or other professional advisor. That is under 9D. This is to protect the confidentiality of information of a scheme member. And in page 16, we have added that it should be in the interest of the scheme members, public interest, enables the exercise of a function imposed or conferred by law. And when a person has received information from the MPFA and the person contravenes the law by passing the information on, then he commits an offense and is liable on conviction to a fine at level 4. Any comments from members? Any questions? Level 4 is how much? 25,000. A small sum. We have taken reference from offenses of similar gravity. I thought that level 4 is 50,000. You sure it's 25,000? Yes, it's 25,000. Please continue. Let's continue to page 17. That is 42AA in the Chinese version is a change of punctuation. It is in relation to restrictions of information disclosure. We have added, that is, in CA, that disclosure of the information is to seek advice from counsel, solicitor, professional advisor. This is a consequential amendment so that it will be consistent with other existing provisions. If there are no questions, we will refer to the next page. It's also a consequential amendment.
Hi.
Yes, please go on. You can go on to page 20. Again, consequential amendments. If information is provided or disclosed by the authority to a certain person, he may not disclose it to another person unless the information is available in the public or if the purpose is to seek advice from professionals such as counsel and, or a solicitor. Okay? Any question? Page 19. Consequential amendments, including the chief executives and so forth. I think there is a difference in the length of the list. Can you please repeat your question? I fail to understand. On disclosure of information, we talked about a list of persons or organizations that may have the information. We've included, say, privacy commissioner. So I think for page 18 it should be very similar, but the numbers do not tally. For instance, here there is no the insurance authority or the Hong Kong MA. Let me first check. Chief Executive, Financial Secretary, Secretary for Justice, Registrar, Commissioner. Yes, we can explain. Because this is about disclosure of information related to the intermediaries. They are regulated by the relevant legislation covering Hong Kong MA and SFC. So for those bodies not included here, they're entitled to seek such information because they are the regulators of these intermediaries. Yes, please. Page 25. The SFC, the Hong Kong MA, and also the Insurance Authority. Okay. So, do you get it? All right, please go on.
Can
I defer to Ms. Lai? All right. Page 21. 42AA. Page 20. This is about the consequential arrangements for disclosure of information under also. It should also correspond to the provisions for MPFA. 42AAB. Our legal advisor has a question. Yes. Regarding section 42AAB in 1A, it says the authority has given written consent and B, any of the following applies, then the administrator under also approved trustee may disclose certain information. So can the administration clarify the following? Under what circumstances or what factors will be considered by the administrator to decide whether the written consent under A will be given? Can I defer to the DOJ to answer? We will have a CSA to this section. We can agree to an amendment.
係咪呢個？
點解要書面啊？
有冇其？
清楚或者佢唔
Perhaps he didn't get your question. Yes, can you please repeat your question? All right, I'll repeat it. Let me rephrase my question. On page 20, we talk about new section 42AA(b). The heading reads, Administrator under also or approved trustee may disclose certain information despite section 41. If we take a look at subsection 1A, certain conditions have to be satisfied. A, the authority, the Hong Kong MA has given written consent, and B, any of the following applies. If these are satisfied, then information may be disclosed. Can the administration confirm? What the authority will consider in deciding whether written consent under 1A should be granted here. So the question is quite clear. Thank you, Legal Advisor, for your question. As suggested by the Legal Advisor, we'll consider listing the circumstances under which written consent would be given. If necessary, we will move a CSA to list out the circumstances under which written consent would be given. But we have to think about the wording of the CSA first. So I can't tell you specifically at this meeting. Please communicate with our legal advisor. Page 22 or page 21. Offense for unapproved person to carry out business as approved trustee. We have adjusted the fine to be consistent with the fine applicable to an MPF intermediary that has committed a similar offense. Page 22. In fact, we have raised the penalty. If the trustee has if a person carries on business as an approved trustee when in fact he is unapproved, if the fine is only 200,000, then the deterrent effect is not too high. So we propose to raise it to 5 million. So, all right. Any comment on this? I'd like to know whether there's been a case in the past. Well, is it a very profitable business?
嚟緊23頁43C。
43C, 43E, and 43F from pages 22 to 24. A consequential amendment to the time limit for prosecution. For some offences, prosecution has to be made within 3 months after the commission of the offence. We have now extended it to 3 years under the amendments here. Pages 25 to 27, terminal illness as one of the reasons for early withdrawal of accrued benefits. And 47C is something new. And that is the extension of the time limit for prosecution from 3 months of commission to 3 years. 47D, new section 47D. Any questions or any comments on this? Vincent Fang, do you have any question? No? No? And then can we go on? Now, I think you still owe us a number of documents. I think we should stop after this page because you have to respond to some of the issues raised by deputations. New 6AA, page 31. New section 6AA, as mentioned by our DS earlier. Now, if a certain fund is not in the interest of scheme members, the authority may reject the application, and this is a relevant provision. And it says here that the relevant applicant can lodge an appeal against that rejection. And page 32, consequential amendments. So amendments to the original ordinance ends here. All right. Do we want to revisit any of the previous points? Any comments? If not, we'll stop here. And please respond to the comments of deputations given on the 7th of October. And also some of our queries. Any other comments? No. Meeting adjourned. Thank you.